to get to all of your questions by the end of the program. With that, I'd like to turn it over to Keith Hesse with Shuffield Lowman.
Thank you, Christian. Can you hear me okay?
Yes, we can hear you. Go ahead.
Very good. Well, thank you all for attending this webinar. My partner Clay Roesch and I are happy to present it, and we thank both MACF and Florida Makes for the opportunity to present and discuss these issues, these timely issues with you. In contrast to the title, we are actually going to hear from Clay first on employee-employer issues and risks, as Clay has a client commitment a little later on. So we will hear from Clay first, and then we will have a period of time for questions and answers on those issues, and then I will proceed with the second part of the webinar after that, and then questions and answers at the end. So with that, I'd like to turn it over to Clay to discuss employer-employee risks and issues in light of COVID-19.
Thank you, Keith. Can you hear me okay?
Yes.
All right. Well, let me start by also extending my thanks to MACF and Florida Makes, Sherry and Christian, and as well to my partner Keith Hesse for all the hard work that y'all have done putting this presentation together. So with that, I'd like to start with just a brief overview of the Families First Coronavirus Response Act. I think most folks have probably read a little bit about this act, so we're not going to spend too much time on it, but we'll just hit the highlights of it. So if we could go to the next slide. The Families First Coronavirus Response Act is the act that contains the emergency family medical leave. It applies to private employers with less than 500 employees, although the Secretary of Labor can make exemptions for employers with less than 50 employees. Employees who qualify under benefits under this act are employees who are subject to a quarantine or isolation order, employees who are advised by healthcare providers to self-quarantine, employees experiencing symptoms of COVID-19 who are seeking a medical diagnosis, employees who are caring for an individual subject to a quarantine or isolation order or who have been advised to self-quarantine, employees caring for a child if their school or daycare is closed due to Corona-19 precautions, and the last category is kind of a catch-all. It's employees who are experiencing substantially similar conditions as specified by the Secretary of Health and Human Services. So what benefits are available to employees under this act? If we can go to the next slide. For the first three categories, that is the employees who quarantine or isolation orders, employees who've been advised by a healthcare provider to self-quarantine, or employees actually experiencing symptoms, they're entitled to 8 hours of paid sick leave at full rate of compensation. But that is capped at $511 per day and a total of $5,110. As you can see up on the slide, for the categories 4, 5, and 6, those are employees who are caring for someone or a child, as well as the employees who are experiencing the substantially similar conditions. They're entitled to 80 hours of paid sick leave at 2/3 of their rate of pay, capped at $200 per day at $2,000 total. And for part-time employees, the amount of the benefit is based on an average number of hours worked over a 2-week period. So those are the highlights of the Family First Coronavirus Response Act. What we really want to talk about in this presentation is managing the risks of coronavirus. And if we can go to the next slide. That is important because we've already seen lawsuits being filed against employers by employees who have gotten sick on the job. Specifically, the first one that we've seen filed was the Evans case that's up on the slide. Mr. Evans was a gentleman who worked at Walmart in Illinois. He got sick. He unfortunately passed away, and his estate has filed a wrongful death claim against Walmart. The allegations of the complaint are that Walmart engaged in willful and wanton conduct because it didn't follow recommended safety measures, and that Walmart should have known, because it was a high-traffic store where Mr. Evans worked, that individuals at his store, at his place of employment, were at high risk of exposure to COVID-19. Now, I want to take a minute to walk through the specific factual allegations because we're going to be using those to talk about what preventative steps we can take to manage the risk of COVID-19. So if we could go over to the next slide. So the complaint that was filed by Mr. Evans' estate alleged that Walmart failed to promote and enforce social distancing, that it failed to provide protective equipment such as masks and gloves, that it failed to warn employees that individuals at the store might have been affected, that it ignored employees who said they were experiencing COVID-19 symptoms, that Walmart failed to follow the recommended guidelines that have been put out by OSHA and the CDC, that Walmart failed to inspect the store for cleanliness and its conditions in order to minimize its risk to employees and other members of the public who came into the store. If we can flip over to the next slide. The allegations against Walmart don't stop there. The complaint also alleges that Walmart failed to provide employees with soap, wipes, or cleaning agents, that it failed to develop policies for prompt identification and isolation of sick individuals. The complaint goes on that Walmart failed to implement engineering controls such as air filters and plastic sneeze guards, that it failed to close the store after learning that employees were experiencing COVID-19 symptoms, that it failed to train employees in proper risk mitigation procedures, and that it hired employees via remote means without personally evaluating their health status. So, if all these allegations are true, and of course we take that with a large grain of salt since they're taken from an unverified complaint, we could see that some of the preventative steps that Walmart could have taken and allegedly should have taken are easier than others. For example, enforcing social distancing, and checking the store for cleanliness, and providing soap to employees are steps that just about any employer can take, and they would address the allegations that we've seen raised in the Evans complaint. On the other hand, some of the remedial steps that Walmart is allegedly failed to take are much more difficult to implement. I'm thinking specifically of providing personal protective equipment given the shortage of masks and gloves. Also, implementing engineering controls is not something that every employer could do. I think my personal Publix is a good example. They've put up plastic barriers between the cashiers and customers, but that's not something that that every employer or every store can do. For example, my drugstore does not have those barriers. So it doesn't take an employee passing away to create potential liability and damages if an employee contracts COVID-19. And unfortunately, there's no one-size-fits-all solution for the preventative measures you can take to avoid ending up in a situation like Walmart. If we can flip over to the next slide, please. But from the allegations of the Walmart case, we can glean some steps that can be taken to minimize liability. So the first thing we can do is provide training for employees on preventative measures. This would involve spending time with your employees, making sure they understand the importance of social distancing, regular hand washing, and if they have them, the use of masks and gloves. You would think this would be fairly straightforward and common sense, but I saw someone recently out in public wearing a mask and gloves pull down their mask, kind of scratch their nose and mouth area, and pull the mask back up, which would not be considered proper use. So spending time with your employees, making sure that they know the steps that they need to take to make sure they're safe would be an important step to minimize your risk. If you have items available, if you provide your employees with personal protective gear, that would be the masks and gloves and the face shields if they're available. Providing those materials to your employees would also help minimize your risk. Implementing and enforcing policies for removing potentially sick employees is a large one. This can include creating written policies, distributing them to your employees, and if possible, having your employees sign a document acknowledging that they received a copy of the policy. That would be very helpful to have in your file when an employee, if they unfortunately become sick and they claim that they were required to come to work, you can point to the policy that shows no, they don't, and in fact they received and read that policy. Some of the other steps that you can take are sanitizing your work and customer spaces. That would include both daily sanitation as well as if you have shifts of employees or people coming in at different times, sanitizing and cleaning workspaces in between those shifts to minimize the potential spread of coronavirus. Can we flip over to the next slide, please? All right, other steps that you can take, if possible, and I know this isn't feasible for everyone, but another step you could take would be to create a work from home program. To the extent that administrative personnel or someone who doesn't have a hands-on manufacturing role can work from home as opposed to coming into the office, that helps create the social distance that minimizes the virus spread, can help lower your risks. Similarly, for the employees who do have to come to the work site, discouraging them from congregating together by closing break rooms, spacing out work areas and cubicles, and essentially anything that you can do to create space between your employees can help prevent the spread of COVID-19 and can help minimize your risk. Still looking at the allegations that were made against Walmart minimizing or eliminating rotations of workers at different job stations so that you don't have multiple people using the same equipment. Screening new hires for potential COVID-19 exposure is another step that you can take. And when you believe that an employee, or when an employee believes that they may have contracted the virus, don't wait for a positive test result or a doctor's note. Go ahead and enforce the social distancing, have the employee stay away from the work site. Again, we've got a reference to the written policies. If you have them in place, signed by your employees, that will provide you with some protection against a claim that can be made. And the sort of last allegation that was made against Walmart was taking other appropriate and reasonable steps suggested by federal, state, and local governments. Now that is directly related to the allegation that Walmart failed to comply with OSHA and CDC guidelines. Now, of course, we know that the government's recommendations have changed as the COVID pandemic has gone forward. I know less than a month ago that CDC's position was that folks didn't need a face mask when going out in public, and now, of course, they're recommending everyone wear face masks. And I even saw recently a short video of the Surgeon General just demonstrating how to make a homemade face mask out of a bandana. So guidance from the federal government, at least, has been changing, but for purposes of minimizing your risk, following the guidance that has been issued can be important. And so for that, I want to take a little bit of time and go through the OSHA guidance that was cited by the plaintiff in the Walmart case. If we can go over to the next slide. And as we're going through these, you'll see that a lot of the OSHA guidance does seem to be common sense. Again, some of the steps that we've taken or we've discussed are actually addressed as part of the OSHA guidance, but it obviously doesn't hurt to have reviewed the actual guidelines themselves and even have a copy saved in your administrative file. If you look at the bottom of the slide that we have here, we've given you a link to the actual publication where you can go download the PDF of the OSHA guidelines. They're only about 30 some odd pages long. So if you can, download them, take a look, and of course, to the extent possible, follow those guidelines. So as we're going through these, do keep in mind that the guidelines will vary depending on how at risk your employees may be. So OSHA provides for 4 different risk levels. There are employees who are considered a very high exposure risk. Those would be the doctors and nurses, the people who have direct contact with individuals who are known to be infected with the virus. There are the high exposure risk employees. That category would include hospital staff. Those are individuals who are in an environment with people who are known to have contracted the virus. The third category, medium exposure risk. Those are jobs that include frequent and close contact with people who may have been infected as opposed to people who have known to have been infected. The example OSHA gives here are high volume retail and school jobs. And finally, the last category you probably can guess is the low exposure risk. These are jobs that do not require contact with people known or suspected of being infected. These would be workers who have minimal occupational contact with the public or other coworkers. Now, most manufacturing employees will probably fall into the low exposure risk category, but even within those categories, the level of employee risk falls on a spectrum. Even though it's not a high volume retail store, if employees are interacting with a large number of coworkers, their risk will be greater than employees who may simply come into an office, shut their door, work for 8 hours and then go home. So keeping that in mind, the fact that OSHA has different recommendations for employees in different categories of risks, up on the slide we have the generally applicable recommendations from OSHA. The first one is developing an infectious disease preparedness and response plan. This is essentially making sure that you have a playbook in place to take steps to prevent or minimize the risk to your employees. The plan should consider and address the level of risks that are associated with various work sites and the job tasks that workers perform, and should consider and address steps that employers can take to reduce the risk of worker exposure in the workplace. The second guideline is preparing to implement basic infection prevention measures. This can include everything from promoting frequent and thorough hand washing, or if running water and soap is not immediately available at the job site, providing alcohol-based hand rubs, assuming that they contain at least 60% alcohol. This also includes encouraging workers to stay home if sick, encouraging proper respiratory etiquette, which would be covering your mouth when you cough, when you sneeze, washing your hands after you do so. It would also include discouraging sharing of equipment such as phones, desks, and offices. I think I touched on this earlier, but if you have multiple employees who are using the same machinery or sharing a computer, you should consider whether or not you can limit that shared use, require sanitation of the equipment by the employee when they're done using it, or setting a minimum amount of time between when one employee stops using the equipment and the next employee starts. Again, the goal is to minimize the risk, minimize the potential for the virus to spread in the workplace. The next guideline is developing policies and procedures for identification and isolation of sick people. This would include encouraging your employees to self-monitor for signs and symptoms of COVID-19 if they suspect that they may have been exposed to an infected individual. This also includes developing policies and procedures for employees to report when they're sick or experiencing symptoms. And again, getting a written acknowledgement from employees that they've received, read, and understood any policies that you develop is a good idea. The next OSHA guideline is developing, implementing, and communicating about workplace flexibilities and protections. We did touch on this earlier. This is requiring sick workers to stay at home and, if possible, for workers who can perform their job functions remotely, establishing a remote workplace. The next category is implementing workplace controls. The OSHA guidelines provide that the best way to control a hazard is to systematically remove it from the workplace rather than relying on workers to reduce exposure on their own. Recognizing that's probably not possible for a virus like the coronavirus, OSHA recommends that employers implement controls rather than relying on workers to minimize their exposure. And there are 4 types of controls. There are engineering controls. Those were the controls that were specifically referenced in the complaint filed against Walmart. But these are controls that are the result of actual physical changes you can make to your workplace. These would include installing high-efficiency air filters, increasing ventilation rates, putting in physical barriers between employees and the public and employees and their coworkers if it's possible. The second form of control are administrative controls. These are measures that require employees to take certain actions, including requiring sick workers to stay home, minimizing contact amongst your employees, clients, and customers. So requiring the use of conference calls instead of face-to-face meetings would be a good example of an administrative control. Also reducing the total number of employees in a facility at any given time. This would be establishing alternating days or alternating shifts so that you have fewer employees gathered in one place at a time. The third type of control is what OSHA deems safe work practices. These are practices that employees can use to minimize their risk. Examples that OSHA has provided of the safe work practices are providing tissues, no-touch trash cans, hand soap, the alcohol sanitizer if soap and water is not available, as well as disposable towels for workers to clean their work surfaces. And the last workplace control is the personal protective equipment, or PPE. These are the gloves, goggles, face shields, and face masks, the equipment that you can use to try and prevent the spread of the virus. So the OSHA guidelines do set out the most effective to the least effective controls. Obviously, engineering controls are considered the most effective. You're placing actual physical barriers between people, and the effectiveness decreases with each particular level of control. So while engineering controls are generally considered the most effective, the personal protective equipment would be considered the least effective type of control. And the last thing, once you get through the controls, the last thing that's included in the OSHA guidance for preparing workplaces for COVID-19 is following existing OSHA standards. If we can go to the next slide. So what should you do if you expect an employee has contracted or been exposed to COVID-19? Well, you can ask your employee about their symptoms. If you notice them coughing in a private place, and the same goes for taking an employee's temperature. You are permitted to do that so long as it's in a private place. If you suspect an employee has COVID-19 or has been exposed to someone who does, quarantining them and all potentially sick employees is absolutely a step that you could take. Separating out that person from the rest of your workforce will absolutely help minimize the spread of the virus. Once that person is removed, you should absolutely disinfect all of your workspaces, and you should also inform any individuals, coworkers, anyone else who may have come into contact with that potentially infected employee that they may have been exposed to someone who may have the virus. Now, it's important that you do maintain confidentiality, so when you inform coworkers or other individuals that they had contact with a potentially infected person, do not identify the potentially affected employee. Keep all of their health records confidential, and you should enforce isolation for any individual who came into contact with a potentially infected employee until they can be tested. So I know in some circumstances, if you have a small office or a smaller workforce, it will be obvious if someone looks like they've been feeling sick and then all of a sudden doesn't show up for work for 2 weeks. It's become obvious as to what's going on, but still employee confidentiality, particularly as it relates to health matters, should be observed. So those are the steps that you can take to minimize your potential risk from COVID-19 and claims that your employees may make if they are exposed to the virus and they claim to have been exposed as a result of coming into work. Now, if we can flip over to the next slide, there are some steps that you can take if you do find yourself facing a claim that an employee got sick or contracted the virus at the workplace. When the coronavirus first started infecting people, it did not appear like the sickness would be covered by workers' compensation. Workers' comp usually does not apply to an ordinary disease of life, such as the cold or flu. There are exceptions to that rule, and as the pandemic has progressed, it looks like COVID may actually be an exception, particularly in light of the quarantine and stay-at-home orders that have been issued. COVID-19 is looking less and less like an ordinary disease of life. As a result, in the event that you do face a claim due to an employee contracting the virus, it may be covered by your workers' compensation, and that's certainly an avenue that you could explore. You take a risk if you take the position that the claim is not covered by workers' comp. The remedy is a lawsuit by your employee against you, where you have the potential of a verdict with damages, punitive damages, and the uncertainty that goes along with all jury trials. I think the Walmart Evans case is the prime example of that. If we can flip over to the next slide. There are other potential avenues where you could find coverage for claims asserted by an employee who alleges they've contracted the virus at their workplace. If you have business interruption insurance, that may provide coverage for the claim. It's generally triggered when a policyholder sustains direct physical loss or damage to insured property caused by a covered cause of loss. Your commercial property insurance may provide you with some coverage. This would be more for losses sustained when a civil authority prohibits or impairs access to your premises. Additionally, your general liability insurance, your CGLs, DNOs, and ENOs may provide coverage for claims. And if you had the foresight to purchase communicable or infectious disease coverage, obviously that would provide coverage for a claim from an employee. So I have one other area that I want to cover real quick. If you are find yourself in the unfortunate situation where you have to potentially lay off a significant number of employees or close a plant, if we can go over to the next slide. You need to make sure that you comply with the provisions of the WARN Act, that is the Worker Adjustment and Retraining Notification Act. It applies to employers with 100 or more full-time employees who implement plant closings or mass layoffs affecting 50 or more employees. It requires employers to give 60 days calendar notice prior to any plant closing or mass layoff. There are exceptions to that. If the layoffs are for less than 6 months, your employees may not suffer an employment loss and notice may not be required. There is also an exemption if the mass layoffs or plant closings are the result of a natural disaster or unforeseeable business circumstances. It's unclear whether COVID-19 would be considered an unforeseeable business circumstance or natural disaster. It's also difficult to project how long layoffs may last, whether or not you would get to that 6-month threshold. And so it's always better to provide notice if you can. And it's also important to know that an employer relying on one of those exemptions still has to provide as much notice as possible. And it must also give a brief statement as to why the notification period was less than 60 days. Now, again, because notice can't be given retroactively, it's always better to provide notice, even if you think you're falling into one of the exemptions. Now, for the WARN Act, penalties for violation can be steep. The penalties for violations are up to 60 days of back pay and benefits, and that would be for all of the employees. So you're looking at 60 days back pay and benefits for a minimum of 50 employees. And there's also a civil penalty of up to $500 per day. Now, the law also provides, the WARN Act provides for a private cause of action. So regardless of whether the Department of Labor is going to strictly enforce the WARN Act during the COVID crisis, you could nevertheless find yourself responding to a civil lawsuit brought by an employee who's been laid off. So if you find yourself in a position of having to lay off more than 50 employees, or you have a plant closure, it's our recommendation that you work with an attorney to make sure that you comply with the provisions of the WARN Act. And so with that, I guess we'll open it up to questions from anyone before we go to Keith.
We have a question here. What is the appropriate process for monitoring employees' temperature prior to entering the workplace?
So the appropriate process would be, if you want to take an employee's temperature, you take them to a private area and then ask them to have their temperature taken. It's not something that you should do, at the front door of your facility in full view of everyone, but you certainly do have the ability to take temperatures before employees can come in. You could implement that in any number of ways. You could do it as a sort of a general screening measure. You could also do it when you believe or suspect that someone may not be feeling well or may be sick.
Thank you. If there are any other questions at this time, please go ahead and type them into the chat box. Clay, if a business with less than 100 people has a layoff, does a notice have to be given?
No, the WARN Act only applies to employers with 100 full-time employees. So if you're less than 100 full-time employees, the Act's not going to apply to you. You're not going to have to worry about it.
Thank you. Would it be okay to erect partitions to take employees' temperatures before they enter the building?
I'm sorry, I did not catch that.
Would it be okay to erect partitions to take employees' temperatures before they enter the building?
So the key to doing that would be ensuring that there is privacy as you're taking the temperature. Again, with anything employee health related, privacy of the employee is going to be paramount. I guess the answer depends on what type of partition. If you're talking about putting up like a shower curtain, that might not be sufficient. If you're talking about erecting, for example, cubicle walls, that might be. It's going to depend on the circumstances and how you set it up.
Thank you. There are companies in other states now using thermal imaging of all employees as they enter. One, is this a process that could be utilized? And two, are there approved or unapproved methods of taking temperature?
So I'm not aware of any approved or unapproved methods of taking temperature. I think the potential for using some sort of thermal imaging or taking temperature that way, at least to flag employees whose temperatures may be elevated. That could be a way to do it. Certainly, it's a little bit less invasive than putting a thermometer in someone's mouth. But no, I'm not aware of any approved or unapproved methods of taking temperature.
And then lastly, is there Is there a procedure for taking the temperature of the first employee to arrive at the workplace?
I'm sorry, I guess I don't fully understand the question in terms of, who would take the first employee's temperature, or you mean procedure by, how it's actually done? I mean, obviously, if you're taking temperatures and you're going to be in close, contact with your employees, you should, take as many precautions as you can with masks and gloves. If you're going to be taking temperature of multiple employees, sterilization, of the equipment is important. You don't want to have a situation where, you have a bunch of employees gathered, queued up in line, one right after another without any space between them. You may actually be creating an environment where it's easier for the virus to spread. But in terms of taking the first employee's temperature, I would assume that you would have, if you're going to be taking temperatures, you would have somebody present whose job it is to do that, and they would arrive first every morning.
Okay. And last question, and then we'll continue on. If masks are provided and required, what do you recommend if someone refuses to wear them?
Well, I mean, you obviously can't hold somebody down and put a mask on them. If someone refuses to wear them, I think you can point out to the policy that you've implemented that everyone should wear masks if they're in violation of the policy. And some of it depends on how you want to proceed with it. That you could, assuming that the individual is an at-will employee, you could simply terminate their employment. You could write them up. You could take any number of disciplinary steps to enforce the requirement that masks be worn.
Do you know if homemade masks are approved? Or
So there's a
mask?
whole set of masks that can be utilized. Given the shortages in inventory that we've seen of masks, gloves, other personal protective equipment, some masks or some protection is better than others. Obviously, most folks are not going to have access to an N95 mask like they use in the hospitals. Like I said, I've seen the Surgeon General put out a video showing how to make a bandana into a mask. I have a cloth mask that I use when I go out in public at this point in time. So, it really is what you're trying to do is minimize risk. There's no way to eliminate it entirely, unfortunately. So, to the extent that some mask is better than no mask, then I would say yes, homemade masks are acceptable.
Okay, thank you. Thank you, Clay. With that, we will go ahead and move on to the second half of our presentation with Keith Hesse. If you continue to have questions, please go ahead and type those into the chat, and we will address those questions at the end of our presentation.
Thank you. Thank you, everybody.
Thank you, Clay. If you could go to the next slide, please. Thank you. Well, that's a lot of information about dealing with employees, a lot of issues, and we could spend a lot more time on that. But given the time we have, we're going to now look at our risks and challenges regarding non-employees, which is basically everyone else. That is, okay, we've dealt with the issues inside the plant, the facility, the office. What about working with our vendors and suppliers, our customers, or if we're a tenant, working with our landlord, or if we are the landlord and lease or sublease space, what issues are we facing? Next slide. So one term you're going to hear, you probably heard it already, is the Latin term force majeure. And force majeure literally means superior force. In law, it refers to an unexpected external circumstance which would prevent a party to a contract from meeting its obligations to perform. Given that, a party may, and I'd underline the word may, be able to avoid liability for non-performance by declaring force majeure. Next slide, please. So there are really two essential elements for force majeure. One is that the circumstance or event must be unexpected and unforeseeable. In other words, no one reasonably could have anticipated it occurring. such like anyone thinking Carrot Top could ever make a go of it in show business, something totally unforeseeable, for example. And number two, it would have to be outside of the party's control. It's not something that the parties would have created. And we'll go into some examples of that, and you see the language in various contracts. So what are some typical events that would qualify as a force majeure event? Next slide. So certainly war, you often see that listed in contractual provisions. That would qualify. Next slide. Riot, insurrection, those sorts of things. You see those terms utilized frequently with force majeure. Next slide. Then forces of nature, hurricanes, tornadoes, floods, and you often see them grouped under the heading of acts of God. Those will typically qualify as a force majeure event. Next slide. So what about coronavirus and governmental action? Would those qualify? Not sure. You can see the question mark underneath each one of those on the slide. Starting with governmental action, there's been a lot of governmental action, and the answer to that is it may. Certainly if an operation is shut down by the government, a government order or decree, that would qualify. But one thing you may think of, for example, are restaurants. So with our folks that own and run restaurants, they're not entirely shut down. They can still provide for takeout or drive-through, but no restaurant dining operations. So would that qualify as a force majeure that would excuse the restaurateur from contractual obligations? With respect to coronavirus, that's an open question. Typical contractual clauses don't normally list pandemics or epidemics or disease events as coming within force majeure, but given the pandemic nature and the widespread nature of coronavirus, that the view on that may be changing. One thing that is not seen typically as a force majeure event is a market downturn. Obviously, there's been a market downturn, as we all know. If we have the courage to look at our retirement statements or 401k statements, there's been a big market downturn, and that typically is not included in something that would be considered force majeure. Next slide, please. The terms of your contract are going to be the key to this, because that's what the courts look to determine whether something is or is not within the force majeure definition or provision. And as I mentioned, typically few contracts include disease, epidemics, or pandemics in the list of force majeure events, but that doesn't mean they can't. This is a matter of pure contract, agreement of the parties, and those provisions can be tailored to include or exclude what would be considered. They can also define or set forth what the results of a certain force majeure event would be. That is, does it totally excuse performance? Does it merely delay performance or any other provisions? So it's very important to look at your contractual language. It's a very good time to examine that language, and if need be, to revise that language or add a contractual provision on it. As you know, we're working our way through this. We all hope to get to the point where the economy is fully back and people are fully back to work, but there may be a rebound. We don't know. This may be cyclical. We don't know. So it's certainly a good time to make sure that your contractual language has provisions in it to address these circumstances of whether that would be force majeure that would excuse non-performance and what the results of that would be. Next slide. So what if your contract doesn't have a force majeure provision, or what if you don't even have a written contract? What if the arrangement you have with your vendor supplier is just a very simple purchase order, one page, no, or only the most general terms, or it was an oral arrangement or series of emails? Are you out of luck? Next slide. You may still have remedies if you're the party that feels your performance has either been prevented or stopped or temporarily delayed because of a force majeure event. And the two that the law recognizes are called impossibility of performance and frustration of purpose. Next slide, please. So impossibility of performance is what it sounds like. It's going to discharge a party from performing contractual obligations when it's impossible for that party to do so, and that party neither assumed the risk of the impossibility nor could have acted to prevent the event, rendering the performance impossible. And typically, obviously, with coronavirus, you have not you can't act to prevent the event necessarily. You may be able to, given what Clay spoke about, minimize some of the risks or results from that event. And of course, most people don't assume the risk of that impossibility. So when we look at the cases, and they're very construction around an industrial area had been severely damaged, if not destroyed, by a weather event, and the owner wanted and contracted to have it erected again, and the contractor could not get government approval to do that, to rebuild the fence and the gate, and the court held that constituted impossibility of performance and excused the contractor from having to perform that contract. For manufacturer, I think you can think of examples. If you can't get essential materials or components for a product or an item you're producing through no fault of your own, and you didn't assume that risk, then the likelihood is your performance of that would be excused. That's similar to sort of the standard riot. Sometimes you see labor shortages in force majeure clauses, that sort of thing. So that certainly would constitute impossibility of performance. So you do have that even if you don't have a contractual provision. Next slide. Frustration of purpose. This is a little different than impossibility of performance. Frustration of purpose, once again, doesn't have to be in a contract, excuses performance by a party when the value of performing the subject of an agreement has been frustrated or destroyed. And as the slide notes, it's not limited to strict impossibility of performance, but it includes impracticality due to unreasonable expense or sometimes futility. So some examples of that in the case law, there was a secured party that held a security interest in various property and also had a personal guarantee against the owner of that property. And the guarantee, by its terms, required the creditor to first pursue foreclosure of the property before it went after the owner on the guarantee. The creditor determined that the property was basically underwater, such that a foreclosure proceeding wouldn't get it anything. In fact, it would cost it. It would end up in a negative. And so on appeal, the court excused the creditor from going through with that because it was impractical and it was futile. Not that the creditor couldn't have done that. Another example we see a lot in dealing with clients that put on conferences or even concerts, events, performances, this comes into play. I mean, you can hold a concert, but if you can only have 10 people there, that really frustrates the purpose of the event and of the essential purpose of the contract. It's going to be interesting to see. I mean, we see it already with conferences being canceled, either delayed or postponed or actually ended, and whether remote access or Zoom or whatever is a suitable equivalent to that, or whether that would actually be a frustration of purpose. In terms of manufacturing, an example may be if you were in a joint venture to produce a part or a component for a customer, and it's a special order, and that a recipient is shut down as a result of the coronavirus. Let's say you're producing something for the Smithfield Foods plant in Sioux City, South Dakota, and that plant, as you know, has been shut down because of rampant coronavirus infection. That would be a frustration of purpose. In other words, you could still produce the item. It's not that you're lacking the materials or the manpower, but the whole purpose of that was to provide it to this recipient, which is no longer in business. So that would be another example of frustration of purpose, once again, even if there is no contract. Now, failure to pay for something that's been produced and delivered is rarely, if ever, going to be appropriate for either frustration of purpose or impossibility of performance. And in fact, it actually may be used, frankly, as an excuse by a party to say, well, you know, because of this coronavirus, I can't pay for this equipment or this product or this item or this delivery, et cetera, et cetera. Many actual force majeure provisions exclude payment as relief for force majeure. It may excuse other performance, but typically not payment. And rarely would payment be excused under impossibility of performance or frustration of purpose. So that's important to know as well. Next slide. Landlord-tenant issues. And of course, everything I've said up to now would apply to landlord-tenant as well. If you have, you know, you're a tenant or you're the landlord, the same things. If you have a force majeure clause, if not, if you look to impossibility of performance, or if you look to frustration of purpose. Once again, the restaurant example, it's one thing if the place is entirely shut down. It's another thing if you can carry on some operations. The courts will look first to the contractual language, and then they will look to the circumstances to see whether there's either impossibility of performance or frustration of purpose. Next slide, please. Now, the government has stepped in. You may be aware of this. Governor DeSantis did order a 45-day moratorium on foreclosures and residential evictions. Now, you may hear some differing things about that. The foreclosures are not limited to residential foreclosures. It's both commercial and residential. But the governor's order only applies to residential evictions, and it is set to expire May 18th, 2020. Next slide. Now, courts around the state have issued their own orders pertaining to the foreclosure and landlord-tenant cases that are pending in those courts. For example, the Ninth Circuit, which is Orange and Osceola County, they have suspended all commercial and residential foreclosure actions or matters relating to those actions through May 19th, 2020. You cannot get a foreclosure sale scheduled right now. You cannot move your case forward right now at all, whether it's a commercial or residential foreclosure or a residential eviction. Volusia County's put it out even further to June 1st of 2020, so we keep an eye on what the courts are doing there. Next slide. Now, neither the governor's order nor the court orders provide relief from paying rent or making your mortgage payments. They're just providing a moratorium or suspension on actions to enforce the foreclosure or residential eviction. Those must continue to be made. And another interesting aspect is you can, the moratorium only applies to failures to pay. So you can proceed with either residential eviction or commercial foreclosure or residential foreclosure if the breach is not one that is a failure to pay rent. That is, if you're dumping hazardous chemicals on the property, or you're violating some other provisions of a lease or mortgage that endangers the property or the value of the property, those proceedings can still go forward. The courts are still open. They are operating in a different manner, as is most everyone else. Trials have been suspended. Obviously, we don't want to congregate juries and venires for juries, so things are going to move a bit slower in terms of court proceedings, but hearings are still being held remotely. Filings are still occurring, except the progress of the foreclosure and eviction actions I mentioned. So things are going to take a little longer to come to final resolution, certainly with no trials being scheduled indefinitely until further order of the Florida Supreme Court. Next slide. So just to put some final punctuation marks on what we've been talking about, and I think, as everybody knows, this landscape is extremely fluid and ever-changing, and it's very hard to keep up and stay current in these areas. And just because you think you've got a fix on things now, what happens if there's a new governmental order? We went through a bit with essential and non-essential businesses, and until we sort of got an amended order on that. Unfortunately, manufacturing seems to always be considered an essential industry under those orders. But it is important to keep up and stay current as to what is going on. Commitment to an exercise of best practices, and I think it came through with Clay. Every HR person would tell you, with employees and certainly with third parties, you need to be proactive. Doing a lot of those things is great. Doing some of those things is good. Doing none of the things that we've talked about is not going to be very good and will not bode well for you. Certainly document efforts. Once again, as your HR folks would probably tell you, and we have a saying, if it's not recorded, it didn't happen. Do the best you can to document policies and procedures. If you can get policy and procedure in written form, that's great. Distributed, that's better. Signed by the employees, that's wonderful. But you need to do as much as you can. Looking at the Walmart case and thinking about the approach that the plaintiffs are taking, I think we have a feeling that we're all in this together. And if judges and juries see that the employers or the business owners did try and do the best they could or take reasonable steps to address this, it's going to look a lot better for them than, say, a former employee or another part of a contract trying to punish them and really pounce on them. And lastly, I would, of course, recommend that you seek help and consultation. No one entity is the master and sole repository of all this information. I think, frankly, wonderful area of help is MACF and your RMAs, your Regional Manufacturing Associations, if some of you are not within Central Florida. They have a lot of information, a lot of contacts. I know that they and Florida Makes are doing these webinars at least once, if not several times a week, to keep everybody up to speed. These webinars are recorded, as Christian mentioned. They're available. And contact your RMAs and contact Florida Makes. And of course, the RMAs work very closely with Florida Makes to get information out there, to provide resources, to connect you to the right people, whether it's within the manufacturing industry or to third parties, associates, professionals that you need to talk to. So those are the things I think to keep in mind and make those efforts and just stay on your toes, and good luck to everyone. So with that, I see it's a little after 3, but I'm certainly open if there are any questions.
Thank you, Keith. Yes, we do still have some time. If there are questions at this point on anything that Keith or Clay spoke on, go ahead and type those into the chat box. Hey, Keith, we have a question here. Any
Yes.
special situation for a tenant between leases?
In terms of what? Is there any follow-up on
Eviction.
that?
Yeah, is any special situation for a tenant between leases when it comes to eviction?
Well, once again, the moratorium is for residential eviction, but generally, all I have seen, I think, the landlords, many times they're in a tough spot because they're obligated to their bank or financing source, and they depend on that rent as their revenue stream. But I have seen that landlords will be amenable to discussing abatements of rent or moratorium on rent. And depending on the circumstances, you have to look at the lease. There may be other provisions in the lease that are involved that frustrated the tenant's operation. Usually there are provisions for, or sometimes for, governmental orders that may affect the business. If you're in a multi-tenant space and you rely somewhat on a lot of traffic, and everybody else has been shut down, and you're the only one there are restrictions on you. You may not be able to operate. The lease may not allow you to go dark, for example, obligate you to maintain operations, and that may be difficult to do. So you'd have to look at the lease, and certainly I think for the most part, communicate with your landlords. I think most of them are being pretty reasonable about offering some flexibility and concessions, if you will, at least on abatement, not necessarily forgiveness, but abatement of rent and other obligations, because I think they know it might be tough to get another business back in there.
You kind of touched on this, but a follow-up question to that: what can be done to prevent eviction for a restaurant tenant unable to pay expensive rent and sales decrease to 20% regular sales? What is the best way to try to decrease rent price?
Frankly, I would say go to your landlord. I've talked with a number of other attorneys who represent landlords, and we've seen it ourselves, that they may be flexible and amenable to a rent abatement in terms of the situation that's ongoing, especially given the alternative. Yes, they can still file that commercial eviction, but things are moving a bit slower in the courts. Now, if you have a lease provision, and many leases do, more on the retail side than, but still, even on non-retail, that requires you to operate, in the premises for certain, periods of time, Monday through Friday or whatever, 7 days a week from such and such, and you can't, or you can't because you can't have dine-in facilities, you may have an argument that the purpose of that lease has been frustrated and you should be released from the performance, and that should not be considered a breach. But that's very, very fact specific.
Thank you. Another question here. If you have a business and due to COVID-19, your customer is not paying you on time, can you claim force majeure? Our customers are mainly cruise lines, which have been highly impacted. We are having problems with cash flow and can't pay our vendors at the moment. This particular business, 50% of their business is with the cruise lines.
Right. Generally speaking, force majeure does not include payment for services that have already been rendered. I mean, you know, the old saying is you can claim anything you want. Is it going to stand up? So if the services and the product have been rendered, for someone to say, look, you know, this is what's happened to my business, that is unlikely to be a legal justification for failure to pay. Because as you know, that can happen anyway with particularized businesses. And so that's probably not going to be a successful invocation of force majeure. I think that entity would be better off trying to negotiate either an abatement or postponement or some reduction or something like that.
This question is, does force majeure break the entire lease or just pause it? And hopefully it will not last forever.
That depends. First, you look to the language of the lease, and once again, I'd encourage everyone to really look, if they have leases or contracts, to look at those and look at the language, because whatever you agree to, whether it's a delay or total end of the contractual arrangement, is going to be based on the language. But clearly, if you look at other provisions, if you have to get a product to a certain customer by a certain time, and that's just not possible, it seems to me that ends the obligation. Now, if there's sort of a longer time specified or no time specified, it may not end the obligation. The other side may just say, well, your performance is delayed, it's not excused, and that's kind of tough given the circumstances. But many times the force majeure will be held to end the agreement and the arrangement and the duty to perform.
Thank you. Are there any other questions at this time? We'll give it another minute or two. If not, okay. Again, this has been a recorded session, so all these questions, again, with the presentation, will be available on our YouTube channel. I should have that up within 24 hours. Also, Keith and Clay's contact information is provided on this presentation, so if there are further questions that you think of afterwards, please don't hesitate to reach out to MACF, to Florida Makes, or to Keith and Clay directly. We would be happy to get you in touch with the correct person to field that question.